Hello viewers, I am Dr. Wajida Rahman. Today we will discuss marriages among Hindus under the law relating to Hindu marriage. The main objective of this module are to know about what marriage is under Hindu law, to know about the impact of marriage in Hindu society, to know about the laws relating to marriage in early Hindu law. Let's introduce the topic. According to Hindu beliefs, weddings are seen as arrangements made in heaven but later formalized on earth, since they are believed to be predetermined by a divine force. The sacrament notion involves the performance of Vedic mantras and rituals. Its purpose is to cultivate strong moral character and produce intellectually gifted offspring, thus contributing to the advancement of the human race and the attainment of moksha. Various Hindu law text writers such as Apastamba, Buddhayana, Kattayana, Gotama, Parashkara, Kotilla, Manu, Yajnavalkya, Narada and Jimutavahana, etc. develop regulations based on the Vedas concerning marriage in order to uphold societal and religious harmony within society, ultimately aiming to achieve overall well-being for all individuals. The institution of marriage serves as the foundation for maintaining many aspects of societal functioning, since it is primarily the responsibility of married individuals, namely husbands and wives, to maintain and manage various aspects of society. The institution of Hindu marriage is intricately connected to the philosophical principles that underpin Hinduism. The matrimonial bond, as a result, persisted as an indissoluble and everlasting alliance in the context of religious belief for a span exceeding 2500 years. The notion of marriage has undergone significant transformation due to several socio-economic developments in society, including industrialization, urbanization, individualism, and the empowerment of women. The Kolhapur Divorce Act of 1919 was the first state legislation concerning the dissolution of marriage. Subsequently, the Hindu Marriage Act of 1955, which applies to all Hindus, was enacted as the first central statute. These legal developments have established Hindu marriage as both a sacrament and a contextual agreement. The document exhibits characteristics that align with a contextual format. The persistence of the sacrament notion is evident in the continued practice of shastric ceremonies and other religious and customary rituals, which are seen as essential for the solemnization of Hindu marriage. The notion of Hindu marriage has undergone a transformation, progressing from the recitation of Vedic mantras to include religious obligations, sacramental significance, and contextual elements. Hindu marriage is a significant religious ritual that is documented in several Hindu scriptures, including the Hindu Shastras, Manusmriti, and other texts such as Yajnavalkya Smriti, Kautilla's Arthashastra, Puranas, commentators, and digest writers. Let's discuss about the sacramental nature of Hindu marriage. So, Hindu marriage is of two different natures. One is the sacramental nature of marriage. Dharma has a significant place within the Hindu concept of life. It is therefore observed and implemented within the context of marriage. The institution of Hindu marriage is considered as a sacrament in various contexts. According to the Vedas, it is emphasized that the practice of dharma should be undertaken by individuals in conjunction with their spouses. As the male is the head of the family, it is incumbent upon individuals to fulfill their domestic and religious obligations by doing the Pancha Mahayajnas, which can only be accomplished via the institution of marriage. In event of the wife's death, the man would engage in a subsequent marriage to partake in the practice of Mahayajnas. Additionally, it is important to note that marriage is traditionally seen as a religious ritual, necessitating the solemnization of a marriage ceremony in the presence of a divine entity. The ceremonial event serves as the essential moment when the young woman transitions into the role of a wife, establishing the marital status of both individuals involved in the union. In historical context, it was seen that although men were permitted to engage in all sanskara rituals throughout the later centuries, however, ladies were not afforded the same opportunity. Consequently, marriage emerged as a significant samskara that was expected to be observed by every woman. Moreover, in order to absolve the indebtedness owed to his forefathers, an individual must procreate a male offspring with the intention of liberating his ancestors from the torments of the afterlife via the observance of the ritual known as Shraddha. Consequently, the institution of marriage, seen as a sacrament, necessitated mutual adaptation between man and women. This is a requirement with the ultimate aim of attaining dharma, offspring, and the fulfillment of bodily needs. In accordance with the Hindu Dharma Shastra, marriage is seen as a sacrament representing a sacred and enduring relationship between a man and a woman. This union is intended to facilitate the fulfillment of religious obligations. The Dharma Shastra places significant emphasis on the enduring devotion that a woman is expected to demonstrate for her husband over an extended period of time. The sacrament of marriage was conducted within the context of a common family structure. The members of the joint family collectively fulfilled many responsibilities and upheld the sanctity of marriage by engaging in shared activities under the guidance of the head of the family, who is known as the Karta. The concept of marriage as a legal agreement, and that is the another nature of Hindu marriage. In contemporary society, the institution of marriage has undergone a transformation, evolving into a contextual arrangement. Marriage has two distinct qualities, namely contextual and status-related aspects. The institution of marriage confers legal recognition on individuals, establishing a framework within which certain rights and responsibilities emerge. Marriage is transformed into a contextual agreement via this process. In contrast to a commercial contract, a sui generis contract has unique characteristics in many respects. However, it raises similar issues as other contracts such as void, voidable, consent obtained through fraud, and dissolution of marriage. Regarding the status of married individuals, regardless of the specific form of the contract, marriage establishes an agreement between the parties that the husband will provide for the wife and the wife will remain faithful to her husband, with both parties fulfilling their matrimonial obligation effectively. Once individuals participate in the institution of marriage, both parties are unable to terminate the union without intervention and approval of a court. Hence, it is important to note that, unlike other contextual agreements, both parties involved in the marriage contract are unable to unilaterally terminate the agreement. Marriage encompasses a set of rights and responsibilities for both parties involved and may be legally enforced in a manner similar to other contractual agreements. These rights may include entitlement to financial support, the ability to dwell in a shared house, the determination of child custody, etc. The enforcement of Hindu marriage is carried out in accordance with many civil laws, including the Hindu Marriage Act of 1955, the Hindu Adoption and Maintenance Act of 1956, the Hindu Succession Act of 1956, the Protection of Women from Domestic Violence Act of 2005, and the maintenance provision under criminal law. In this context, marriage might be seen as a combination of elements from both sacramental and contractual frameworks, rather than strictly adhering to either one. If a Hindu individual enters into matrimony under the Special Marriage Act of 1954, it is to be understood that the marriage would be classified as a civil contract, since the performance of basic marriage rituals is not required for the formalization of the union. The parties involved in marriage should possess the necessary competence, such as the bride being a minimum of 18 years of age and the bridegroom being a minimum of 21 years of age. Many Hindu law scholars have suggested that Hindu marriage is seen as a sacrament rather than a contractual agreement. According to Mullah, Hindu marriage is considered a sacrament, but divorce is seen as a legal concept. According to Section 12, Subclause 1, Subclause C of Hindu Marriage Act, the consent of the persons involved in a marriage is a crucial factor. If this assent is gained through force or fraud, the marriage is considered voidable. The inclusion of ingredients often found in contracts as outlined in Section 5, Section 11 and Section 12 establishes the contractual nature of Hindu marriage. According to several scholars, Hindu marriage is considered to include characteristics that resemble both a sacrament and a contract, rather than strictly conforming to either category. The sacramental institution of marriage has seen a decline in its significance since the 1930s. There are numerous factors contributing to the evolving nature of Hindu marriage. These include limited access to India's spiritual teachings, the complexity of the country's spiritualism, weakening religious ties, the decline of Varna Dharma, that is the caste system, less adherence to Brahmachari ashrams, less respect for religious marriage ceremonies, non-marital relations, the effects of industrial revolution and urbanization, democratic ideals, more interaction between man and women, the empowerment of women, and changing gender roles. Now we are going to discuss about the different forms of Hindu marriage. Marriage is categorized into 8 distinct types according to normative literature, dharma text, and some shastras. The existence of 8 types of marriage among Aryan Hindus was acknowledged by the Supreme Court of India in the case of Kopisetti Subbarao versus the state of Andhra Pradesh. The 8 kinds of marriage may be classified into 2 distinct categories. Number 1, approved forms, and number 2, unapproved forms. Under the approved forms category, Brahma, Deva, Arsha and Prajapatya are recognized as legitimate types of marriage. These matrimonial unions include the act of bestowing gifts, specifically referred to as the gift of a maiden, that is the Kanyadan. According to the Dharma text, Brahmins are obligated to receive gifts. Hence, it is commonly acknowledged that the first 4 categories of matrimonial unions have legal validity for individuals belonging to the Brahmin caste. Next, the Brahma form. The practice of Brahma has a prominent place among the 8 types of marriage in India, being widely observed and regarded as the most superior. The Manusmriti also places significant emphasis on this kind of marriage. The concept of the Brahma marriage, as described in the Dharma text, is the bestowal of a daughter by her father, adorned with ornaments and esteemed with jewelries, to a suitable qualified groom chosen by father himself, with extensive knowledge of the Vedas. The Brahma weddings refer to the ceremonial practices observed by the Brahmins as outlined in Manusmriti, which stipulates their obligation to receive offerings. Next, the Deva form. The term Deva Viva refers to a kind of marriage that is associated with the ritualistic practices of deities. In this kind of matrimonial arrangement, in contrast to the Brahma form, the paternal figure bestows his daughter onto a priest as a dakshina, which serves as a sacrificial remuneration for the priest's role in overseeing the ritual done by bride's father. In this marital arrangement, it is the parents of the bride who actively seek a suitable spouse for their daughter, rather than the groom initiating the search of a wife. Next, the Arsha form. The third recognized type of marriage, known as Arsha marriage, entails union between individual and rishis or sages. The Arsha type of marriage distinguishes itself from a Brahma and Deva form by the absence of any material exchange from the bride's father to the groom. In the Arsha form, it is customary for the father of the bridegroom to provide a gift of 2 cows or bulls to the father of the bride. Nevertheless, this particular kind of material union was not seen as prestigious, since it included treating marriage as a commercial transaction involving the trade of bride for livestock, namely cows and bulls. Prajapatya form. The Prajapatya form of marriage bears resemblance to the Brahma form of marriage, with the exception that it lacks the elements of trading or kanyadan. In Prajapatya form, it is the responsibility of the bride's father to actively seek out a suitable groom for his daughter. The first stipulation put forward by the father of the bride is that the bridegroom must see the bride as an equal collaborator and jointly fulfill their obligations both in the realm of religion and in secular matters. According to Manu, the progeny of a woman wedded in accordance with the Prajapatya ritual has the ability to emancipate 6 generations of forbearance and descendants. Now we will discuss the unapproved forms of marriage. In unapproved forms of marriage, Asura, Gandharva, Rakshasa and Pishasha are classified as non-conventional or orthodox kinds of marriage. In the case of Rajveer Singh Dalal versus Chaudhary Devilal University, it was determined that in situations where a woman is married in an unauthorized manner and remains childless, her property is legally entitled to be inherited by her family rather than her husband. The Asura form. This particular kind of marriage is often criticized. In this customary practice, the father bestows his daughter on the bridegroom after providing all possible assets to both the father of the bride and the bride herself. The Ramayana text reference the bestowal of a substantial dowry on the guardian of Kaikeyi in exchange for her marriage to King Dasharath. This scenario may be seen as a business transaction in which the bride is acquired through a purchase. In the case of Kailashanath Mudaliar versus Parashti Bedivanni, the Madras High Court provided a standard for evaluating the classification of a marriage as asura or not. The act of groom providing monetary or equivalent value such as wheat or cows to the bride's father as a kind of compensation or advantage in exchange for the marriage of his daughter is often referred to as an asura marriage. Gandharva form. This particular kind of marriage is distinct and diverges from other manifestations of marital unions. A consensual agreement has been reached between the female and male individuals to enter into matrimony. This mutual agreement is the result of intense desire. The influence of parental approval is negligible. In the case of Bhaurao Shankar Lokhande and another versus the state of Maharashtra and another, the Supreme Court engaged in a comprehensive examination of the necessary rituals involved in the performance of a Gandharva marriage. Within this particular cultural context, father of a female individual touches the foreheads of both the female and the male counterpart, therefore symbolically completing the Gandharva union. Rakshasa form. This Rakshasa types of marriage is characterized by the abduction of the bride, followed by the violent elimination of her family and relations. In some textual sources, an additional need is stipulated whereby the groom is expected to engage in a conflict with the bride's family during a peaceful wedding ceremony. Nevertheless, the presence of this condition is not a prerequisite for the occurrence of a Rakshasa marriage. According to the esteemed Indologist P.V. Kane, this matrimonial arrangement is designated as Rakshasa marriage due to historical accounts that associate Rakshasas, malevolent beings, with inflicting brutality upon their captives. In contemporary times, the aforementioned act is classified as a criminal offence under Section 366 of Indian Penal Code. The act of abduction or kidnapping a woman with the intention of coercing her into marriage is subject to legal consequences, including an imprisonment sentence of up to 10 years and or a fine. So, in conclusion, it can be said that marriage has had significant societal importance throughout the history. Dating back to the prehistoric times, marriage is the unification of individuals of both male and female genders in both physical and spiritual aspects. Sociologists have proposed multiple definitions of marriage, including Malinowski's characterization of it as a contract for the production and maintenance of children, and Robert H. Lewis' view that marriage is a relatively permanent bond between permissible mates. The fundamental purpose of marriage is to establish a relationship between a husband and wife. According to Hindu law, marriage is considered a holy bond and is regarded as one of the 10 sacraments that are deemed indissoluble. Moreover, this ties is inherently formed from one's birth to another's. According to Smritikas, the bond between individuals remains unbroken even in the face of death. That's all for today's lecture. I hope you have enjoyed the lecture. Thank you very much.